Ladies and gentlemen, it is my special pleasure to introduce you to Professor Dr. Marie-Claire Faublet and to be able to listen to her at this exciting time. Why it is an exciting time? After all, her assumption of the role as the new director of the Max Planck Institute for Social Anthropology in Halle heralds new avenues of research at this distinguished institution. Yes, I would say so. As time presses, please allow me to briefly sketch out but a few stations of an impressive academic resume in which the interest in other legal cultures has always played an important role. Professor Dr. Faublet is the director of the Department of Law and Anthropology at the Max Planck Institute for Social Anthropology in Halle at Saale. That means you, studied law, philosophy, and anthropology at the University of Antwerp and the Catholic University of Leuven, where she received her PhD in social and cultural anthropology in something. She has taught inter alia at the University of Antwerp, the Catholic University of Brussels, the Université Paris 1, Sorbonne, and at her alma mater, the Catholic University of Leuven. There, before assuming her current position as director at the Max Planck Institute, she was professor at the Faculty of Law, where she was inter alia chair of the Institute for Migration Law and Legal Anthropology. Let me name just a few publications of Professor Faublet that are particularly worth noting at this occasion, and there, listen well. Les familles maghrébines et la justice en Belgique, anthropologie juridique et immigration en 1994. Relations familiales, interculturelles, cross-cultural family relations, some years later. Le code marocain de la famille, incidence au regard du droit international privé en Europe, de 2005. And cultural diversity and the law, state responses from around the world. An important book for our debate, especially also in this center. 2010. So, how religious pluralism and perhaps also legal pluralism is reflected in the family ties of a change in Europe is the object of her lecture entitled Religious Pluralism and Family Relations in a Change in Europe, Main Findings of the Religare Project 2010 to 2013. So this is the topic, and now we have the chance and the pleasure to listen to you. The floor is yours. Thank you very much for coming, and very welcome once again at our center.
I really feel like a misfit because I'm the only one who can't speak really sufficient German to do the presentation in German. But if you have questions in German, I would understand them. Let me tell you, Werner, I'm totally overwhelmed. The friendship, the kindness, the generosity, the quality, both of the debates, but also of all the kind of the setting. I enjoy this, what I hope will be a first stay at your unit. And for you, Matthias, what I will say is just a follow-up, because I was thinking of not really an expose here, but of testifying a very recent experience. 1 year ago, about, I think exactly this time, you invited me at your unit to introduce your researchers in what was then still the ongoing research project, what we call Religare, for a much longer title, Religious Diversity and Secular Models in Europe. And then, why did we use this subtitle? I don't know whether I would use it again now. Innovative Approaches to Law and Policy. And the acronym Religare comes, of course, from the Latin word for binding, verbinden. Meanwhile, Matthias, we have reached the deadline, and we have submitted last week what is then to become the final report to the European Commission. We were supposed to submit 31st of May, and we are now waiting for the Commission's, hopefully, approval. No? Now, for our purposes, what conclusion do I draw from this project in light of the tasks I've been entrusted with by Werner and Matthias at this conference? The title of this session is Recht und Religion, welche Forschungsperspektive? So what would research, no? And a future-looking way. Now, I had prepared a very elaborate PowerPoint, and I wonder whether I will use it, because I might lose something of the spontaneity, and I think it's just too elaborate. So what I will do, I will speak in 3 parts. And my first part, on purpose, I would like to devote to what I would call reservations, clear reservations. The second part, and that will probably be the most important for you, are the main findings of this research project. And then the recommendations. What are we going to recommend to the EU when it comes to law and religion? I will leave the slides here so you can have this kind of more detailed, and of course, as soon as the report is being approved, I will make sure I send a copy to Werner and to Matthias, and we will put it also on the site. If some of you would already like to have a look at what we produced within this project, we have a site, www.religareproject, in one word, .eu. Out of the full presentation, I will anyhow use 2 slides, the second last one and the last one. And the second last one, which will be my first slide, I will come back to this. I take from my presentation in Göttingen. And it's about all these kind of critiques I have to myself now after this 3 years round, the reservations, the kind of warnings I wish to express when you just take responsibility for this type of project. It's, so to say, a list of personal reflections. And I think the critical questions one ought to have when accepting to use public money for a research on law and religion in Europe, and moreover to spend it on a research with a policy mandate, which is we are accountable to a policy-making body. I listed basically 7 reflections. Now, to prove that I have an elaborate PowerPoint presentation, I have to go through all my slides because it's the second last slide. See, I've done my homework. Here are the personal reflections. But just before I dig into these personal reflections, basically what was the Religare project? We were a consortium of 13 teams. We covered 10 countries. We have been funded for a project within what some of you may know, the Framework Program 7, for 3 years, starting mid-2010 and finishing, as you now know, late May 2013. This was for me my first EU project. Maybe if it were to be redone, so to say, I would probably take more account of the reservations I will dig into in a minute. We gave ourselves one main mandate. This is to map the extent of protection of freedom of religion, including non-faith-based convictions, beliefs, so the large definition of freedom of religion, to map the extent of protection for 10 countries, which is 9 EU countries plus Turkey. Where do the countries stand? For 4 fields. Employment, for the main reason that we do have a non-discrimination directive to which you... So we have EU legislation on employment, and 3 other fields, and there the choice was a bit principled but also pragmatic. Who are the teams? Where is the expertise? So we have family law, we have space, public space, and that against the background of what then had recently happened with the minaret discussion in Switzerland, what about our public spaces in secular Europe, and state support mechanisms, because one of us is very much an expert. Was it to be redone? I think I would more take account of the competences of the EU, and I would, for example, go for education instead of state support. This is just a critical reflection in retrospect. Where do the countries stand, and what, main question, could be the role of the EU? Ideally speaking, for ourselves, we decided we would have no normative stand. We would work bottom up, and we would collect the data. Which type of data? Well, we were basically half of us lawyers, half of us sociologists, and I think 2, maybe 3 anthropologists, but doing basically qualitative research on issues related to religion. What did we do? We collected case law, as much as we could find, and of course case law is the tip of the iceberg, but it's the legal reasoning that matters. The legislation, is there legislation? By lack of legislation or for lack of legislation, maybe good practices that we could trace. This was the legal data. And then for the sociological part, we also interviewed people. We interviewed around 155 people distributed over these 10 countries. And then we fit, so to say, all these data with a view to the comparison in what we call templates. And in the templates you can see per topic, where does the country stand, where are the tensions, is there case law, is there interesting legal reasoning, and then are we maybe advancing something that looks like a good practice or something that could be an inspiration either for other countries or for the EU. And here, of course, stops the story of a no normative stand, because if you start comparing, if you start thinking of improvement, you need a standard of measurement. And our standard of measurement has, of course, been what is the most appropriate protection. And the most appropriate protection, if I'm now very frank with you, is the maximum protection. So in a way, the whole report reads as a very much pro-minority approach. And I do expect vivid critique for that. I'll come back to that. That's basically what Religare stands for. 10 countries, 13 teams, sociologists, lawyers, and then a big comparative exercise. My main reservations, as I expressed them last year, and I think for me they really stand as main reservations, is what is the EU competence regarding religion? And I'm so happy that you came this morning, because you see it infiltrated, so to say, through this kind of non-discrimination concern and open up the borders. It's the story, the double story, and then all of a sudden you have religion, but religion has become a kind of EU competence indirectly, but there is no long-term view on the side of the EU. So there is this kind of very difficult position the EU is in. The policy mandate is a very problematic issue. If you only have 3 years, if you really go for a bottom-up research with no normative stand, 3 years is killing. It's too short. And then you have to come up. So in the end, you have sometimes to precipitate a number of proposals you advance. A third reservation is the fact that we did qualitative research, and this brings with you the responsibility that you have to insist this is not representative data. This is a sample. We worked in depth as much as we could, but we could have been interviewing other peoples, of course. We could have been selecting other countries. We could have been selecting other social areas. So it's very much qualitative research. The difficulty and the richness of interdisciplinarity. I mean, I'm so happy we did it, but it slows down the rhythm of the work, and it's not sure that we have been discussing the same things. Because your references are... so we had difficult moments, and I think we managed to make the best of it. And I think if I were to ask the 13 teams, everyone would go for another time, but would maybe do it a little bit differently anyhow. Very important also is when you address the issue of religion, you address an issue that has a long history in the countries. So it is very much contextual. All countries have their own troubled relationship with religions. because the religions differ, because the landscape and the kind of the number of religions differ, because the constitutional model is different, because some have gone through revolutions, others have not gone through revolutions. So it's very difficult in terms of when you then start to compare what would be a good practice in one country is not necessarily a practice you can export. So all this kind of contextualization brings with it the kind of the risk of false comparison. So and as you said, the EU story with religion is such a recent story. So all this makes that we were to really be prudent with comparisons. What I have clearly, and I speak in terms of underestimated, is how hugely sensitive is the issue of religion. You can't take a stand and it will be the wrong stand. For some you will have been too secular, as I said, for others we will have by far been too sympathetic to minorities. So it will always be, because for one or another reason people feel either threatened by religion or embarrassed by religion or identify with religion. And for the case law addresses, as I said, 99% of the case law is about religious claims. So the people will tell us, why didn't you look at other claims? But because there is no case law about secular claims. You have a very few. No? And then the last is, what do we do? Because we just established this kind of main comparison in a map, so to say, and we call the map our templates. We do have, I think, an interesting research tool. And now the question is, what do we do with this tool? Maybe because a tool, if you don't update it, it's over. No? So a mapping should be continuously updated. That as regards my reservations. Now, what were the findings? And I will not dig into this by far too detailed PowerPoint. I will reduce my findings to 4. The first, empirical data, as we have been collecting them, show that the premise that our societies would become ever more secular, the hope of some, doesn't hold. But, and there we go, but the policies in general nevertheless stick at this premise and therefore see religion as a hurdle, as an obstacle to successful, what they then call integration policies. However, on the ground, empirically, what one sees is a triple observation, and I think Marianne, who is maybe in the, I think you already mentioned it for Quebec, no? A diversification of the religious landscape with new religions, no? An increased mobilization of religion as an identity marker, very clearly, but also, and I think maybe I speak more for Europe than I could for Quebec, I don't know, an increased success of the non-religious stance in various societal debates. You see a kind of secular militantism, no? When it comes to balancing welfare of animals with, for example, the ritual slaughtering. When it comes to all types of gender issues, when it comes to state support to welfare institutions, when it comes to the plea for a more radical absence of religion in the public space, you have also this kind of radicalization of the secular claim. And the bulk of the data we collected in the 10 countries confirm this kind of triple trend. There is no such thing like ever more secular societies. But there is one thing, there are ever more difficult questions to address. The second main finding, within this traditional, what you then still could call the politically correct view, that Europe, if not does, then should increasingly secularize, some religions, the traditional religions, the majority religions, were granted various types of exemptions. Often also inscribed in the Constitution, which has for long been the highest thinkable status of legal protection. You have your constitutional privileges. And when you see then this long list of historical exemptions, in effect, to be a secular state in Europe comes down to tolerate that one adopts a double standard approach. I think you already mentioned that also this morning, Marianne. Some are more equal than others. You could call this inconsistent, for providing traditional religions, mainstream religions, things you don't grant to others. The king or the queen is also the head of the church. So be it. The secular state paying the salaries of the clergy of traditional majority religions, so be it. The secular state paying for religious education at school, What's the problem? The secular state paying for the renovation of religious buildings of traditional communities? What's the problem? Not to speak of the Christian calendar for fixing holidays. Just another example we referred to this morning. And some others have warned for a similar double standard approach in the case law. Some religions are considered with more leniency than others. And we in Religare, we speak of unnoticed, not to say unfair, anachronisms. Why, for example, is the cross just a passive symbol and is the headscarf a powerful symbol? And we could give many more examples. This brings me to my third, what is another finding, but it's more a point. Neither a double standard approach with greater tolerance for some than for others, nor the premise of increasing secularization with religion seen as a hurdle are a solid base for preparing Europe's future. We are faced, so to say, with our own inconsistencies. And then what can we do? And this is the Forschungsperspektive, from the point of view of our responsibility, which is not policy, but scientific mandate. And I see a number, and I think I will reduce it to basically two. First, I think, and I see here work, empirically based research work, identify very clearly the situations that are not yet, or not appropriately protected under existing state law. And there are a number. And I think we cannot satisfy with parallel legal systems. Let them have their own solutions. I really think we have to be inclusive and fair. One main finding in Religare is, you are so right, the case law is the iceberg. But what is more relevant, some cases will never be dealt with by the courts. People stay away from the courts, the parallel legal systems. Or we always deal with religion as a problem because these people have their claims. But so many more people hide away their religion in order to participate in our society. Is this the type of society that we want to be? And I can give you dramatic examples of women who are totally hiding for remaining digging in their religion, not being a hurdle in our perception of secularized society, and not feeling arguing that they're just what to them is an evidence, their religion. So I think there is a problem of lack of case law, or lack at least of visibility of cases that never come to the court. So we should be concerned about these situations we also never see in the court, and then inventorize, well, still for the research, the reasons for this lack of protection. And maybe it has to do with our concept of religion. What is being granted protection? And when you see the legal reasoning, there is also something like, yeah, a person should be willing to pay the price for her religion because there is also the freedom to resign from your religion. Why doesn't she use her freedom to resign from her religion? Religion is a matter of taste. And then you get this kind of very hypocritical reasoning. If she doesn't go for a backstage position, then it means that she doesn't really, she has to pay the price of the backstage position because we can't suffer her in a front stage position with the headscarf, for example. Religion is a choice, you pay the price for it. Or your religion is against public order. I feel sorry, I can't take account of your religion. So in some, only religion that matches really with our yardsticks, our criteria, are protected. And if you do not fit in the box of a number of preconditions, then there is no protection. I just think of religions, for example, with no representative body. No representative body means no spokesperson with the government. Or you get also the contrary. One fakes religion in order to get the benefits. Now, in some countries, like in my countries, the humanists molded themselves in a kind of cult in order to get the money. Or in other countries, Scientology is being granted tax benefits for being a religion. So you get in the both sides it works. A very nice example, because all of us are blaming, so to say, the European Court of Strasbourg for its Laozi II position. Much more recently, there was a very, very interesting decision, the Ewaida decision of the 15th of January 2013, where you get a really contextualized approach. No? Can, for example, a person refuse, a civil servant, refuse a homosexual marriage? What would be the solution? Conscientious objection, or the task and the duty and expectation of the public service? Can a person, a civil servant, wear a cross? No? So, and you get a very, it's not just a yes or no, it is a very contextual approach. The expectation of the customer, the expectation of the public service, the fact that the person could have negotiated in the right moment, no, what was to her important, and the fact whether objections contention comes first. I mean, a very context, and I think this is a type of fair reasoning. If some of you would like to check the Ewaida cases from the 15th of January of this year. So identify the situations that have no protection or no appropriate protection, and maybe ask very critically the question, the lack of protection may have to do with our concept of religion, and the way we just grant protection to some religions and not to others. And the second kind of task, so to say, for research would then, of course, be the main task, is explore in-depth, long-standing, sustainable alternatives that would allow that religion becomes part of what you then could call, in a cool way, quality management of an inclusive policy. In Religare, I will not develop, but we just proposed 2 yardsticks. We did not invent them. They also come from the literature. We suggest to take as a yardstick inclusivity. Neutrality does not really exist. If you keep it, make of it an inclusive neutrality. And the second is even-handedness, justice as even-handedness, which is much more far-going than just non-discrimination. You have to refine, you have to sophisticate, you have to go for something like justice made to measure. It costs a hell of a lot of energy, but it's worth being tried. And some courts do, and we should highlight these courts' decisions that do the work. And maybe they can become then a kind of source of inspiration for other judges. When I think of the sloganesque way that Europe is defining itself in 2020, it is diversity for growth. We should not only think of disabled people, we should not only think of women, we should also think of these citizens that are citizens with their religion. And so we found a number of very interesting policies, we found a number of interesting techniques. For example, some countries are much kind of more lenient when it comes to granting recognition to religious marriages. There are pros, there are cons, we should not be naive, but there are maybe benefits to be drawn there. To allow people to choose for the law that applies to their family lives, the optio juris, we have it in our law, why can't we extend it to have, even in civil contracts, some clauses of religious law? We do have in business area, we do have it. Why can't we extend it, for example, to family law? So we could, with some arbitration, yes and no, but maybe yes. I mean, why religious arbitration? Anyhow, no. I mean, so we have been thinking of what could be a positive approach to including religion and mainstream religion, to say, in our secular legal system. My last finding, and I really would like also to bring this in, is there is, and we should not be naive, a risk of radicalization. But where does that risk come from? Religion has indeed become a refuge, a backlash identity, both for minorities and for majorities. Now, we have had this discussion this morning on the culturalization of religion, as Olivier Roy calls it. Religion for people has something like a belonging dimension, but there is also the risk of a circulus viciosus. Minorities return, for not feeling really recognized, return to religion as a refuge, and majority societies, they react by approving all types of ad hoc repressive legislation.
the full veil in France is a typical example of an aggressive, repressive legislation. The ritual slaughtering, the way the debates are being kind of dealt with, it's an aggressive, repressive legislation. The issue of the backstage position is exactly the same way. There is really the honor killing. Some countries are now trying just also to criminalize honor killing. Prove me what is a honor killing. No? So there is this targeting, and there is both sides. And then, of course, we should not protect the wrong use of religion. No? So I think there is wonderful reflection by Jean Bobéro. Some of you may know him. He has been doing quite really interesting stuff on religion, sociology of religion. And he says, and I will quote and then translate it, la laïcité, so the French secular model, n'aura pas retrouvé son sens avant que l'on ait radicalement combattu les discriminations. So he says we should take into account that a secular model should also really make sure that it is inclusive. No? A secular model should, donc la laïcité présuppose equal treatment. No? Laïcité presupposes equal treatment. And then when I come to my, what we could advance in terms of policy recommendations to the EU, I have to confess that I'm really stressed. I don't know how the Commission will read our proposal, because they themselves are kind of very ambivalent about it. For some people, clearly, we met with several people at the DG Justice, DG Employment. Whenever you speak of religion, that's not our business. I mean, and other people are interested, but very much on an ad hoc base. Tell me how to solve concretely this problem. We basically have 3 or 4 recommendations. There is this proposal pending, the proposal from 2008 to extend the non-discrimination, including on religious grounds, not only in employment but in all services, which would extend, so to say, the infiltration of EU law in all what is social services and social kind of action in the EU, which would be an enormous extension. But are we supportive of that? If you read carefully the proposal, there is in the proposal the prioritization. We have no problems, and of course for evident reasons, no problems, to show very, very kind of strictly at non-discriminating disabled people. So we put them at the top level. The measures are much more binding when it comes to the disabled people. But the indirect effect of this is that the religious people is in fact less a priority. So what we advance is that we, before just going straight and blind for this kind of approving this directive, that we should think through whether this prioritization couldn't be a priority for everybody, at the same, put them on an equal footing. We had our final conference in December, and we met a number of people of DG Justice, and I think we also should be very realistic. Andreas Stein from DG Justice said, you know, I would really like to take account of your findings, but if you want me to really do this, you have to speak our language. You have to understand that we are an EU with 27 people, and that the proposal of 2008, this is centuries ago. In terms of the climate then was different. Now I find a lot of countries opposing to this directive, so what you should better do, and that I thought was an interesting tip, he said, you should suscitate cases, bring cases to the courts, do the judiciary do its work, instead of pushing us into amendments that we will never get through. I think that was an interesting... Then there is the disposition of Article 17 of the treaty on the functioning of the EU that comes from the Lisbon meeting. In that disposition, there is on the one hand the confirmation that the countries, when it comes to religion, each have their own policies, and that the EU will respect this. This kind of vast historical background is being granted recognition. So the EU will respect all the countries' policies with regard to religion. And then gives a binding mandate to the President to have a dialogue with religious communities. What he puts on the agenda, who invites, what he does with the dialogue, that's it's totally kind of discretion of the president. So what we will suggest is do more with this article. No? There was a claim by the humanists. They said, why aren't we invited around the table? And why isn't there a kind of more clear agenda? And then the ombudsman had a kind of Salomon's position, because he reconfirmed the importance of the dialogue, but at the same time he reconfirms that it's the discretionary power of the president. So I think we will meet the BEPA people, so the people of Article 17 in 2 weeks from now. They already want us that in our way we think that Article 17 could be a platform for a more proactive EU policy, that we have too high expectations. So what means that they are not intending to do anything with our suggestion. Another kind of proposal we have is that you are probably familiar with what is called impact assessment, is that whenever you set up a policy, you think beforehand of the impact of your policy. No? Whether it's for environmental reasons, why not about also when it comes to people's religion and belonging. And then some more pragmatic suggestions. One of them, it's maybe also a bit of critique, that the Directorate Generals with one another sometimes have a discussion, because we sometimes really feel that they are each in their own box, no? And that there is no, as there is no long-term view, it's as if religion surprises the EU, there is also no transversal dialogue between. So there is no kind of contextualized, holistic approach to the homo religiosus, no? At EU level. I think I will leave it at that, and if I survive the next weeks that the Commission is really not too critical, I may then start publishing on this experience. Thank you very much.